Hello, I'm John Ainsworth. I'm the Chief Magistrate of the North Carolina American Republic. And on Thursday, February 3rd, 2011, I attended a presentation by the North Carolina Institute for Constitutional Law. I'm going to give you the purpose statement of the North Carolina Institute of Constitutional Law. It says the NCICL was formed to conduct research, educate, and advise the general public, policymakers, and the bar on rights of citizens under the constitutions of the state of North Carolina and the United States of America. It is furthermore our mission to advocate the principles of limited government and strive to ensure compliance with the constitutional restraints on government. Again, I asked a couple questions. Just take a look at the following video and see what you think.
Yes, sir.
Is there a certain degree of putting the cart before the horse here? In that, we speak fluidly going from the 1776 Constitution, the proposed Constitution of 66, to the Constitution of 1868, and the process that took place which established this new state that entered the Union in 1868. A due process of law following that process in 1867 with the Reconstruction Acts. In other words, is the state that's in place now can't take a legal challenge as to the due process of law and the constitutionality of its foundation. And we're talking about amending this new Constitution, but I'm talking about, are we getting the cart before the horse by not addressing the constitutionality of the Constitution and the due process that put it into place, or the violations?
The Articles of Confederation didn't provide for having a constitutional convention to write the U.S. Constitution, so I suppose the same issue could say that, well, are we actually still under the Articles of Confederation because there was no authority to have a U.S. Constitutional Convention in 1787?
Okay, well, but again, we didn't switch from one government to the other. That was Article 7 of the Constitution said that each state set up a convention, and they chose to either secede from the Articles of Confederation. As you know, North Carolina, when the United States was established in November, in 1788, North Carolina was not part of the United States. We didn't come until November 21st, 1789. So we were out of the Union. We had not chosen to leave the Articles. But once we adopted the Constitution, we had chosen, as a people, the political rights are vested in to go under the Constitution. So the Articles get left behind us. You'll see in Jerry Cohen's response that what he was doing is really sidestepping the issue of, should we address the constitutionality of the Constitution? And he's trying to draw a correlation to the foundation of America at the Constitutional Convention. Most people don't understand that the Constitutional Convention that was held, it was really to amend the Articles of Confederation. And they actually went to a Constitutional Convention without authority to change the form of government. Now, the real issue is that we did not change, and what I say, we did not change from one form of government under the Articles, and then they held this illegal convention that was binding. It was binding on no one. What came out of what we call the Constitutional Convention, even though it was signed, those signatures were not binding on anyone. So what cures this concept that the Constitutional Convention being an illegal convention and therefore we might be under the Articles of Confederation, what cures that concept is that every state had to vote on it by itself of whether it wanted to adopt that. So that state's voting adopted that. Let's go to Mr. Cohen's next response.
In a philosophical sense, I think one could say that the people have the right to establish their own government, and a legislature, a constitution which has a very restrictive right to amend it, that if the people have a convention and approve a new constitution, whether or not it complied with the provisions of amending the old one, I think you could argue the sort of fundamental right of humanity is the right to form its own state, and that it can't be bound by some prior thing. And that's sort of history in Rhode Island in the 1830s, where they had no provision for amending it. There was nearly a revolution in Rhode Island.
Luther versus Borden?
Forcing through a new constitution.
But the Supreme Court ruled on that,
yes.
Basically saying that the Congress had to recognize the charter constitution that came in from the king, and they didn't have any right to rule any otherwise. But I'm talking about in North Carolina, are you arguing that was a lawful constitutional process, Reconstruction was a lawful constitutional process?
Well, whether it was, in 1969, the legislature approved a new constitutional rewrite which was approved by the provisions for in the 1870 Constitution, and which the voters approved a new Constitution. So I would say that if there was a problem from 1868 or 75, that was cured in 1970, would be my answer.
I would tend to disagree because a state, as we all know, is comprised of three components, one of which is the body politic, two is the Constitution, and three is the territory, the soil. The body politic was changed, so we did get a new Constitution over the same soil, but the body politic was nationalized through the coerced amending of the 14th Amendment, which was in Article 5 of the Reconstruction Acts. So we've got coercion, you've got bills of attainder. You have a clear bill of attainder in 1867. Because I'm bringing these into court. I'm fighting these in court because I don't really recognize this state as having a lawful foundation. And we're doing what we consider to be the lawful thing, is challenge it in court. We're having huge difficulties having the court want to discuss this. And I find it very, very strange that a state, when challenged to prove that it's a lawfully created state, refuses to do that, because that's the foundation of all law. Is a lawfully constituted jurisdiction, and if we can't get that jurisdiction set and proved lawful, then does that bind the people to actually obey it? Are they required to obey a government that will not prove its lawfulness? Because that's a huge issue, and Professor here is talking about one of the problems we have is not having an educated populace. And I don't see where this is actually dealt with in our public education system. I don't see where it's dealt with in our legislative part or in the courtrooms. The courtrooms have actually gone the other way. Yes, sir.
Again, Mr. Cohen tends to sidestep the issue by going into a philosophical concepts of that the people have a right to create their own state, and the people do, and that's an absolute correct concept. The issue is what people have a right to create a state, and were they an extension of the original state, or were they a new state? And again, what's very, very clear is a new state called North Carolina with a new body politic was put into place. And so now it gets to be, was that done lawfully and constitutionally? Where's the constitutional authority? It was done clearly with, if you look at your history, with a bill of attainder, which means they convicted a large segment of the North Carolina population without due process of law, and said, you're not allowed to vote. And none of these people were convicted of a crime. This is where you have to take the entirety of the Civil War, which they couldn't do in 1867, of was the war itself lawful? Was secession a crime? So these are some other issues that fall into place here. But let's go ahead and finish up the rest of this conversation.
I would say despite Article 13's detailed provisions of how to amend it, in our State Bill of Rights, Section 3, the people of this state have the inherent sole and exclusive right of regulating the internal government and police thereof, and of altering or abolishing their constitution or form of government whenever it may be necessary to their safety and happiness. But every such right shall be exercised in pursuance of law and consistently with the Constitution of the U.S. It sort of regulates the fundamental right of the people to organize their own
No, I agree with that. The issue is, who were the people? The people originally in the original Constitution was the freemen of North Carolina. Congress made it the United States citizens residing in North Carolina, changed the body politic. And so the issue gets to be, the Constitution of the United States, if you read the preamble, was ordained for ourselves and our posterity. Was it the posterity, were they the people that made that Constitution in 1868? I would dare say not. I would say the Reconstruction Acts had a bill of attainder.
Mr. Hood.
John Hood will resolve this.
Yes.